Hi, I think I can start now. Now's the time to start. My name is David Guillory. I am a litigation director for Lone Star Legal Aid, and I'm going to be talking today about evictions, what's left in Texas. We're still in the middle of COVID. It's still as much of a problem as it's ever been, in some cases worse. But all of the emergency measures that were developed during 2020 that helped so much are fizzling out, if not dead now. So what's left of to help tenants? And as I give this talk on the current state of evictions in Texas, I'm giving it from the point of view of someone, and my sole interest here is in keeping tenants in their housing. I don't care if it's fair to landlords. I don't care about some of the policy issues that affect the legislature or Congress or budgets or anything like that. I just want to keep my clients in their homes. So it's a good thing if it does that, if it's a bad thing if it doesn't. And with that in mind, let's get into it. Okay, current state of the law. As you know, the Texas Supreme Court has issued emergency orders that were to ease various types of issues regarding safety, and a lot of it to deal with evictions in the state of Texas, and all of it supposedly aimed at containing or reducing the effect that COVID is having on the state and the population. Right now, we're in the 47th emergency order. Okay, and all of the emergency orders in the past, they felt like emergency orders. You know, in emergency situations, you do extraordinary things. Keep in mind the pregnant lady who picks up the car that's resting on her child or something. Extraordinary things. Well, the current order, the 47th emergency order, there's nothing emergency about it. It's kind of just a plain order. It gives the courts flexibility in scheduling trials. It gives the courts the ability to extend dismissal deadlines in CPS cases. It gives the courts authority to take safety measures, like require people to wear masks or have hearings remotely. It doesn't help tenants at all in those situations. Luckily, for at least one more month, expiring March 1st, 22, is the Supreme Court's 46th emergency order. It actually had some teeth. And when I say an order has teeth or helps tenants, what that translates to is I can use these orders, and you can use these orders to help get evictions lawsuits dismissed and keep our clients in their homes, at least for a while longer. So if you read through the 46th order, which is good for another month, there's language in there that has to be included in the action for eviction. And that means in either the citation or in the petition. And the information has to be about rental assistance programs. Well, guess what? The rental assistance programs are broke. There's no money left in them. But as long as that rule is in there, it has to be in the pleadings. All right. So, and I don't care if the language that has to be included in the pleadings is a link to or information about discount tickets to Disney World. I don't care what it says. What I like about it is that it has to be in there. Landlords don't know to put it in their petitions. A lot of lawyers practicing don't know to put it in their petitions unless they read through a 5-page Supreme Court emergency order. So the fact that it has to be in there means that I can ask the court to dismiss this lawsuit because the pleadings and the citation are defective because they don't include a link to information regarding rental assistance. Okay. The current emergency order also requires a judge to confirm whether there's a pending application for rental assistance. Well, pending applications for rental assistance aren't going to help much because there is very little rental assistance left. Again, the program is broke. But if the judge doesn't issue that, then there's a defect in it. I can ask for a dismissal. One of the things that I ask clients to do, if they call us before they've been served with papers, hopefully they're going to give us a call as soon as they get a notice of a lease violation or a notice asking for possession of the property. the 3-day notice that they're supposed to get under Texas law. If they'll call us then, my advice is going to be to them, you need to immediately apply for rent relief, even if the program's broke. If by the time we appear in trial, there is a pending application for rental assistance, then I'm going to ask that the case be dismissed or at least postponed for 60 days, depending on what's going on here. Because the 46th emergency order also requires, in cases of pending rental assistance applications, that there be a 60-day abatement of the eviction. It also, in those situations, requires all the parties to make the fact that you've been sued for an eviction, make it confidential. They can't go blabbing about it to other people. It saves my clients embarrassment. Also includes information about how you get the case reinstated after the end of the 60-day abatement. But what I like about it, it gives my client an additional 60 days to figure out their situation, find alternative housing, maybe get a job, maybe get some of their form of relief from somewhere, and straighten out these problems. The order also requires that the judge discuss rental assistance with the parties. That's no longer very interesting because, again, there is no more rental assistance. Okay, more current state of the law. First of all, there is no more moratoriums. All throughout the calendar year 2021, there were moratoriums issued by the CDC and adopted by the Supreme Court that required judges to simply not hold eviction hearings. And that was great. That was great. My clients got to stay in their houses. But that's all gone. That's a thing of the past. The Texas eviction diversion program is out of money. Existing applications are still being processed. But what the heck? I'm going to advise my clients to apply anyway, even though that might be futile. It might get the lawsuit dismissed if there is an eviction lawsuit. The Texas Rent Relief Program that was created by emergency order, it's on hold and out of money. Again, existing applications are still going to be processed. There is still what's left of the CARES Act. We're going to talk more about that in a minute. But what's interesting about it right now is if any property has asked the federal government for an abatement of their mortgage payments, then as long as they're in abatement, as long as those mortgage payments are in abatement, then they can't evict people. So no evictions for rent as long as that property is in forbearance. All right. Now, this only applies to evictions based on failure to pay rent. You can still evict somebody for any other major lease violation. And we'll talk more about that in a little while. But that's a real useful one for any property. And we talked about this here a year ago, is how do you know whether a property is a recipient of some kind of federal assistance or whether that mortgage guarantee is in abatement? You can look it up. There are databases. I think they're linked to our website. I know they're linked to Trala's website, but this information is readily available. Okay, the CARES Act. You remember it from 2021. The CARES Act did a lot of things. It provided for some unemployment benefits that were much needed at the time and are still needed. Those benefits are gone. It also gave people some help with if they're unable to pay rent and being evicted. Section 4024 of the CARES Act still requires landlords to give a 30-day notice for certain federally guaranteed properties. So if a tenant receives a 3-day notice of eviction, then I can get that lawsuit, you can get that lawsuit dismissed because it's an improper notice. What properties does it apply to? Any property that either participates in a qualified housing program or has a federal guarantee from a qualified program like Freddie Mac or Fannie Mae. And that is a surprisingly large number of properties. Most big commercial complexes, whether they're participating in Section 8 or not, probably have some kind of federal federal guarantee on their loan from Freddie Mac or Fannie Mae. Those are the largest lenders in the lending game, and big projects like that probably are participating in that. But these days, most of those properties have a 30-day notice requirement built into their leases, but you still want to double check that. If it's an apartment complex that is 4 units or more, and they receive a 3-day notice, chances are it should have been a 30-day notice, and that's a basis for getting that lawsuit dismissed. Okay. All right. So if there's no more protections left from either the CDC or Congress or the Supreme Court, then we're back to just the same way that we won eviction cases prior to the pandemic. We rely on the provisions of Chapter 24 of the Texas Property Code, which deals with evictions, and we deal with the lease. All right. First of all, in any of these eviction cases, we want to start with the lease. What does the lease say about notice? What does the lease say about the reasons that a person can be evicted from the property? There's always non-payment of rent. You have to pay your rent, and a whole lot of these cases are about that. But a whole lot of cases are about things like you make too much noise, you don't keep your apartment clean, we don't like your guests, we think they're unsavory people, and we're going to evict you for one of those bases. All right. I would certainly want to fight any of those kinds of bases, anything other than non-payment of rent. Most leases require a major lease violation, a major breach of a covenant in a lease in order to declare that lease to be in breach. If I certainly think there's a fact issue if they say, well, we don't like who your guests are, or your apartment's not clean enough, or you make too much noise. I would want to know what happened. I would want to fight it at every detail. I'd find neighbors and other witnesses saying that, no, this person is clean, this person's quiet, and who's to say, what rights we have to have visitors come to our homes. The Fourth Amendment to the United States Constitution gives you a whole lot of privacy protections as to who you can have in your home, what kind of guests you can have in your home. I would want to fight it on each of those bases, particularly the privacy rights that you have inherent in your own home. So those are all things to fight about, and it's usually controlled by the lease. In the absence of a contrary provision in the lease, Chapter 24 requires a 3-day written notice. All right. And it has to be served in a particular way. All right. Chapter 24.005 of the Property Code gives you 3 options, gives a landlord 3 options as to how a notice of eviction has to be served. The first option is to hand it to someone at the apartment or on the premises. That person has to be 16 years or older. What if it's a large kid that is big for their age but they're only 15, but they're large for their age because of all the growth hormones put in their cow's milk that they drink all the time? Doesn't matter. Still has to be 16 years old. The second option is it can be put on the inside of the door. Okay, most landlords have a pass key to a rental place, so they have to go to that place and either hand it to someone in person over 16, or they can open the door after knocking and place it on the inside of the door. If it's just thumbtacked to the outside of the door or taped to the outside of the door, it's improper notice. There is a third option. It can be put on the outside of the door, but in that situation, it has to be in an envelope that's sealed, and the envelope has to say something innocuous like important documents on it. All right. If they do it any other way, or if they just tack it to the door, or if they slide it under the door, that's improper notice, and I would seek to get that lawsuit dismissed. The contents of the notice, the amount of time in the notice, and how the notice is served is where most of the fighting in these rental cases, in these eviction cases, should be. That's the best, most fertile grounds for getting these lawsuits dismissed, is improper notice served in the wrong way. All right. But going back to the lease itself, another major area of getting these things dismissed is there has to be a breach of the lease, and it has to be an important one, a big ticket item. All right. And it's your job as lawyers to contest that. And no matter what the reason is, fight it and disagree with and make them prove that this was a major lease violation, and that the issue is major enough that someone should actually have to lose their home about. Okay. In irregular eviction cases, here a decade or so ago, the Texas Rules of Civil Procedure were amended to add rules for the justice courts. Rule 509 has a list of ingredients that a petition has to have. This is any petition filed in a justice court. There are 6 must-have items on there. If any of those are missing, ask for a dismissal of the case, or at least an abatement of the case while they fix their pleadings. All right. And pleadings are important because that's the due process. Due process says that we have a procedural due process says you have a right to notice of what you're accused of, and an opportunity to defend yourself. If the pleadings don't inform you of that, and the pleadings require 6 things, and some of them aren't on there, then that's a violation of due process, or so you should at least argue. Venue is an important matter. Most Texas counties have 4 precincts. The law says, the property code and the rules say that the lawsuit has to be filed in the precinct where the property is located. Well, you don't really know if the courthouse for a particular precinct includes a particular address. Now you can call the JP's office and ask if such and such address is within your precinct. And if they say yes it is, then it's probably filed in the right place. If they say no it's not, then you've got a basis for either. The property code says in a situation like that, for most cases, you should ask for a transfer of venue. All right. And that abates the case while the case is being transferred. But in eviction cases, I think Rule 510 is about venue, but Rule 736 in eviction case dealing with just evictions says that if the lawsuit is filed in the wrong precinct, you should have the thing dismissed. And it requires the courts to dismiss eviction lawsuits filed in the wrong precinct. So you win that one. And they have to go through the process of reserving notice, paying another filing fee, filing it at the courthouse, and having that served on someone. It creates more hassle, more time, more expense for the landlord. And again, our goal of having our clients stay in their homes longer is met. Let's see, also in the petition, going back to the specific eviction petitions, that's Rule 736 of the Texas Rules of Civil Procedure. In addition to the 6 must-have items that have to be in any pleadings, there's 5 additional things that have to be in a petition for an eviction, a forcible entry and detainer lawsuit. If they're not all there, I'd seek dismissal or an abatement while they fix their pleadings. One of those 5 items is a requirement that in the pleadings, they list how and when notice of a lease violation or notice of eviction was presented or served on the tenant. If it's not one of the 3 ways that we discussed a little while ago in chapter 24, that lawsuit should be dismissed. So it's not only got to be in there, but it's got to be something that is acceptable under the law. Also, if they're saying that there's a major lease violation, whatever they put in their petition has to match whatever was given on the notice that was the 3-day notice that was delivered a few weeks earlier. If on that notice they say you're too loud and you're cause too much disruption of the facility by having guests in the parking lot late at night, and the lawsuit says something like, we don't like your guests, or they have the wrong kind of guests here. Well, that's not a good match. It doesn't put, the petition doesn't put anyone on notice of what it is that they've done to violate a lease. So that lawsuit should be dismissed, or so you should argue. All right. The court will set, there's tight deadlines for how long a court has to set an eviction pleadings. One of the things that both the current emergency order and the 46th emergency order that's still in effect does is give the courts a lot of leeway in adjusting pretrial and trial deadlines. So that could be extended for a reasonable amount of time, could even be shortened for a reasonable amount of time, although I don't see that very often at all. But those are procedural things. They don't really affect whether you get to win or lose the case. But any kind of extension of a deadline is good for your client because it gives them more time to figure out their financing or figure out where they're going to go next, or figure something out in case they lose the eviction lawsuit that you're representing them on. Keep in mind that justice courts are not courts of record. There are rules of civil procedure, but there's no rules of evidence. The court can base the court's decision on whatever the court wants to, and doesn't even have to articulate it. There's no requirement in a justice court that the judge gives the parties a reasoned opinion as to why or how it's doing what it decides to do. So for that reason, as lawyers, we want to be in a court where, oh, another thing about justice courts is there's no requirement that there be lawyers there. As lawyers, we have an advantage over a non-lawyer landlord or non-lawyer representative of a landlord. So we like to get to county court at law where courts issue reasoned decisions. There's rules of evidence that give you an advantage as a lawyer. So once you have a right to appeal any loss in a justice court, same as these, you got 5 days to do it. So because there's a 5-day right of appeal, the writ of possession, the document giving the landlord the right to actually get you out of the premises can't be issued until the 6th day after the decision is made by the justice court. And you can never be actually forced out of the home without a writ of possession issued by the court. So that gives you an additional amount of time there. I like to, if we ever lose these things, I like to go ahead and file my notice of appeal while I'm there at the courthouse on the same day that the hearing was held. And I like to, when I go to court, I like to have a pauper's affidavit with me. I don't use an affidavit form. I use a declaration form. That way I don't have to have it notarized, and I can get it on file with the court on that same day. We don't have to make another trip there or rely on the mails or something like that, because a 5-day deadline is very short and you don't want to miss that. All right. If you lose in the justice court and the issue of the eviction was non-payment of rent, you're going to have to put up a deposit. Because we're legal aid and we represent indigent clients, a pauper's affidavit saying that you don't have the money and are not capable of putting up the money should suffice in any issues related to filing the appeal, but it won't help you with the requirement that you continue to pay rent. So you're going to be asked as a tenant who lost at the justice court for non-payment of rent to deposit money in the registry of the court equal to the amount of rent, and you have to do it each month. Okay. Last year, this is my favorite slide here, because remember last year, the CDC offered us so much. We were getting these eviction lawsuits dismissed due to a CDC recommended moratorium, and those recommendations were adopted by the Texas Supreme Court. So we had the highest court in the land in Texas saying there's a moratorium on evictions. That helped us so much. We got so many eviction lawsuits dismissed and frustrated so many landlords. Those were good. These days, the CDC isn't offering, but there is some CDC protections for renters. You can still wear a mask. You can still wash your hands. But other than that, I can't think of any. So the days of CDC protection from getting evicted, they're about over, unless something else happens that gives more teeth to that. Okay. I'm not sure how much time we have left, but one of the things we like to do whenever we're talking about evictions is trying to anticipate what questions that get asked by tenants usually. I've got a few of the greatest hits here that I want to talk about. Do I still have to pay rent after being sued on an appeal? Yes, you're always obligated to pay rent pursuant to the lease agreement, as long as you occupy the premises. If it's on appeal, then you're usually going to be asked to put that rent in the registry of the court. During the moratorium, we had clients that didn't pay rent for 6 and 7 months during the pendency of the moratorium. And maybe that wasn't fair to landlords, but that wasn't our problem. That was the landlord's problem. And as advocates for tenants, they're our only concern. Can the landlord remove me from my apartment? No, again, you can only be forcibly removed from your apartment with a writ of possession. And that is only going to be issued after all of the process of a lawsuit is filed. And even if you lose that lawsuit, you can still appeal it to a higher court. Once you lose in the county court at law, if you're going to lose in the county court at law, then a writ of possession can be issued by that court. And it's probably time to move out at that point. Okay. Can a landlord still file an eviction lawsuit against me even though the pandemic's still going on? I mean, the pandemic's as bad as ever. The headlines still say that people are still dying. The hospitals are crowded. The healthcare system's falling apart. There's still people getting sick in record numbers. But all of the efforts that we spent the last year doing, they're exhausted. There's no more money. There's less political will to do something about it that costs money. I think our lawmakers are tired of fighting it, just like all of us seem to be tired of fighting it, but the problem hasn't gone away. So these days, you can be sued even though the pandemic's going on. It's happening a lot. There's a great number of eviction lawsuits that were filed after the moratorium was lifted. They're still in the pipeline. I still have a few that are a while old, and I'm just keeping them alive by looking for procedural defects or other arguments that'll keep my client in the housing for a little bit longer. Can I be evicted for getting sick? Look, I have COVID. I can't move. I'm quarantining. I can't do that. Yes, you can still get evicted for being sick. No, the landlord can't ask you about your illness, can't sue you because you're ill. Again, it's your home. And the fact that you're ill, you have certain privacy rights related to that. It's still your home. So the basis of an eviction can't be that you're sick. But if you fail to pay rent or there's another lease violation, you can still be evicted even though you're ill and aren't in a position to leave. So be careful about all that. I'm going to look at the chat here. That's pretty much what I wanted to talk about. Okay. If anyone else has a question, please put them on the chat. Otherwise, that's about all I've got for you. And I'm running out of time, I just learned. So thanks for listening to me, all 6 of you out there. and um, keep on defending these lawsuits if you get them. Thanks.